Welcome to In Your Defense with Amy Bingham.
Hello and welcome to In Your Defense with experienced attorney Amy Bingham. Thanks so much for being here. My name is Kevin Rosenquist, and today we're going to talk about what you can expect for your first time in court. This should be interesting. Amy, great to see you.
Good to see you too, Kevin.
All right, so it's probably a big question, but what should someone expect when walking into a courtroom for the first time? And maybe like, how is it different than what we know from the media and TV and movies?
So in television and movies, you often see the first time in court is trial, like in Law and Order. It's almost always trial. Sometimes they'll do what's called an arraignment.
Yep, I've seen the arraignments, yeah.
Yeah. So typically the first time you come into a courtroom, if you're involved in a criminal case, it's going to be your arraignment. And in Oregon, we do what's called an arraignment on information to begin with. And that is the first time where the defendant is going to be told what they've been charged with. And so a judge will call the case, and your attorney or the attorney who is assigned to do arraignments for that day will stand up, and then you'll stand up next to them. They will show you the information sheet or the charging document and ask you to confirm that your name is spelled correctly and that your date of birth is correct. And then that attorney will go through the arraignment, which typically sounds like, Your Honor, on behalf of so-and-so, I can acknowledge receipt of the information. Their name and date of birth is correctly set forth. We waive formal reading and advisement of rights, and then that's it. Okay. So formal reading, what that means is that we're telling the judge they don't have to read the document to you. So it saves time, a lot of time, if we don't have to read through every single charging document. And then advisement of rights, we also typically waive because that's something your attorney can talk to you about, and you don't need to be told by the judge. And those rights are that you have the right to an attorney and that you have the right to go to trial, to force the district attorney or the state to prove the charges against you. You have the right to confront witnesses and to confront evidence and to bring your own witnesses and bring your own evidence. You have the right to remain silent or to take the stand. You have the right to a jury or a trial by judge. So these are the things that we would be talking to you about. So on your first time walking into court, you will be expected to sit in what we call the galley, which is the area behind where the attorneys stand. And then when it's your turn, you just simply get up and walk to stand next to your attorney.
Okay. What's the atmosphere like? There's
typically a feeling of expectation or nerves in general with people. Mm-hmm. For the professional staff that are there, the judge, the judge's assistants, the attorneys that are there, the bailiff, it's, business as usual and a bit boring, if you will.
Yeah.
So it's routine. It's something they see all day long.
Yep.
So you're not going to see much reaction there. The other thing that you might find happening on the first time is a discussion of whether or not you get bail or get released. If you were in custody for your arraignment, then that definitely will be something that is discussed. And you won't be standing next to your attorney. You'll likely be standing behind glass in a back hallway.
Yeah, a little different than what we see on TV. What are the key differences between a trial and other types of court appearances, like hearings or motions or things like that?
Right. Okay. So a trial happens at the end of your case. It is almost the very last thing that happens in your case. Sentencing is technically the last if you are found guilty. Motion is a hearing that is done when one side, one attorney or the state, the district attorney, asks the court to do something and the other side disagrees. So for example, if you are out of custody waiting to go to trial and the court gave you release conditions, such as have no contact with your alleged victim, you can't enter bars or taverns or OLCC outlets, things like that. And let's say that your job is a bartender, then I may have to file a motion asking the judge to amend your release conditions so that you can go to work.
Gotcha.
Without being in violation and being arrested, essentially.
Right.
So that's typically what a motion is. And those are specifically set by the attorneys with the judge's staff to make those arguments. The other type of court appearance that you're going to have most often is called a status or a pretrial. And that is where the attorneys tell the judge where we're at in the case, whether I'm still doing an investigation, whether I'm waiting for this report or that, need discovery, all of those types of things, all the way up to I'm ready to resolve the case or I'm ready to set a trial date.
Okay. How important is courtroom etiquette? What are some of the mistakes that people make when they're new to the courtroom? Because they're obviously, like we talked about in previous episodes, they're nervous, they're scared, whatever. Like, how important is that to keep it together?
So courtroom etiquette is really important. Judges get to set the rules for their courtrooms and they take it pretty seriously. And you should always remember that the judge is the person that's making decisions about you and what's going to happen to you. Mm-hmm. And that may not mean that if you get all the way through a trial and are found guilty, that this particular judge will be sentencing you. But this judge might decide whether you get to stay out of custody or not. If you are disruptive, you could be held in contempt, which could be a fine or it could mean you go to jail for a few days. So courtroom etiquette is important. You never want to speak unless you have been spoken to. You want to keep your phone on silent. Children shouldn't attend. You want to dress appropriately. So I typically tell people, think about what you would wear if you went to church.
Okay. Yeah.
So, no t-shirts with profane language or obscene images. I have seen judges send people to the hallway to flip their t-shirt inside out because they felt it was inappropriate.
Wow. Okay.
Yeah. So it kind of reminds you of school.
Yeah. Yeah. It's been a while since I've been asked to turn my shirt inside out. That's happened.
A good tip, right? I think a really good tip is if you're accused of something like, let's say robbery, and the person who is in the video of the robbery is wearing a red t-shirt, don't wear a red t-shirt to court, right? Self-explanatory, but it's not. Don't do that.
That's really funny.
Yeah.
And good advice. How do you treat the judge and how do you address the judge in your first appearance? Like, how do you, how do you keep the judge on your good side?
So you just want to be respectful and play by the rules. And so your attorney will tell you what those are. Essentially, I need you to stand to this side of me or this side of me. I need you to, pay attention. Don't smirk. Don't laugh. Don't roll your eyes. Any of those things that, that we all do on a day-to-day basis because we really do live in a casual society.
Sure.
That's not the place to do it. You want to address a judge as your honor or judge. Sir, ma'am, miss are not really appropriate, but won't get you into trouble.
Okay, that's interesting. Yeah, it sounds like I'm asking you for myself. I assure all the listeners, this is just a podcast. Can you sort of walk us through the basic structure of a court hearing? I mean, you gave us a little bit of details on the arraignment, but
Sure.
Who speaks when? What should someone be prepared for?
Let's say a pretrial, for example, in a court that does those in the courtroom. Either the judge or the district attorney will call a case, which means they'll call the case number and state your name. So if it was me, they'd say, State of Oregon versus Amy Bingham, case number 24 CR, blah, 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 blah. And then the attorney assigned to that case will get up and approach counsel table. There's usually tables or podiums in the courtroom, and one is set aside for the district attorney and one is set aside for the defense side. And so you approach the table and you're always going to stand to the outside of the attorney. So you're not going to stand between your attorney and the district attorney.
Yes.
Makes them nervous. They don't like that.
That makes sense.
So you don't do that. So you're just going to approach, you're going to stand there. You may not have to say anything. If the judge says good morning, you say good morning. Essentially, you speak when you're spoken to. Think of it sort of like military school. You don't want to speak out of turn. If you have a question, it's best to ask your attorney and not ask the judge, because anything you say is being recorded and will be used against you, which I'm sure you're familiar with hearing it on television, right?
Sure, absolutely. So they should just kind of whisper to you if that's
Right.
They have something.
Right.
Okay, that's allowed. That's not disrespectful.
Right. We have mute buttons on the microphone. Yeah,
Gotcha.
Definitely allowed and not disrespectful. You may have to wait a moment until you certainly don't want to interrupt the judge. If the judge is addressing your attorney directly, just wait a second and maybe just get your attorney's attention that, hey, I've got a question for you. And they'll ask the judge, say, if I can have one moment, and then you mute the microphone and then talk.
Okay.
So yeah, that's allowed.
Okay. That makes sense. Yeah.
Yeah.
Do you have any practical tips that you give clients for staying calm and focused during their first court appearance, especially if they're in kind of like it's kind of a scary or intimidating situation?
Yeah, I do. I always tell them this is just one step in the process and you're not going to jail today.
Right.
Unless there's a possibility they might be.
I might go to jail.
Right. And usually I would have a heads up and know what's going to happen. And they would know well before that happened.
Sure.
Other times that it's possible is if you have not been arrested, but have been indicted secretly and they've asked you to appear at court and it's very serious charges, let's say murder or a Jessica's Law situation, then it's entirely possible that you might be taken into custody at that arraignment. But again, that's something that we would know about ahead of time and give you a heads up about. I also advise people to, try and stay calm. And it doesn't matter what anyone says here. This is not going to determine your fate or your outcome, guilt or innocence.
Right.
Alleged victims typically have the right to make a statement. And so they'll often use any appearance as an attempt to convince a judge or anybody else of their allegations, that they're right and you're a horrible, horrible person.
Right.
And so you don't yell they're lying. Don't do that.
Well, that's not fun. That's not what you see in the movies.
I know, right? No, you don't get to carry on and do anything fun like that. It's not, we can't be, screaming, I want the truth. That's saying I want to go to jail for contempt, Your Honor. Pretty please take me out. Yeah. I always remind them it's not important. What they say here doesn't matter. And in fact, it's helpful because now I've got what they've said on the record. And so I can use that to impeach them if they say something differently later. Plus, it gives me a heads up as to what they're saying outside of what they've said to the officers. And again, it makes no difference to the outcome of what's going to happen to you, what they say at that moment.
Yeah.
And then it's easy to just forget about everybody else that's sitting in the back.
Yeah, for sure. For sure. And do you have to have you had situations where you have to kind of take a moment and calm someone down because they're a little too freaked out?
Absolutely. Happens fairly often, and that's perfectly normal. I've also had to calm people down who have reached, their breaking point and being incredibly inappropriate. I've had a client who slammed his fist down on the table and then charged around to try and get to the judge on the bench. And that was a whole interesting situation.
So don't do that is what you're saying.
Don't do that.
Oh, wow.
All he did was add 2 years to his sentence because he got 4 consecutive contempt charges.
Yeah. Oh my goodness.
Yeah. So you don't want to do that. You want to, calm down. If you're about to lose it, tell your attorney and we'll ask for a break and step outside.
Yeah.
There's always something that we can do to, fix the situation, but don't lose it in court.
Yeah. Hold it together.
Mm-hmm.
What should someone do to prepare for their first court appearance? Are there specific documents or things or evidence that they should have at the ready?
So not at a first court appearance.
Okay.
If you have documents or things that you think might be important, bring them and give them to your attorney, but you're not going to be giving the judge or the prosecutor any evidence at an appearance. You definitely do not want to write a letter to a judge because judges are not allowed to receive letters from people. So if they do, they have to give copies to both the defense counsel and the district attorney. And so basically, if it's something that you're going to say, it's going to be said to everybody. And so it's better to talk to your attorney about that beforehand and make sure that you're not shooting yourself in the foot.
What is the typical reason for doing that? To garner sympathy or?
Yeah, people think same thing with why they speak to officers. If I can convince the judge of my innocence, he'll let me go now. Things like that. And that's just not the way the system works.
I know that.
Yeah. Once you've been charged, there's a process and you're not going to get out of it right then and there.
Yeah. You got to go through the process. You know that part. Once you're there, it's like, okay, I got to go through the system that we have in place in this country.
Right. And just like with police, you have the right to keep silent. Use it. That applies through every court appearance. If you can avoid putting something on the record, then you avoid it. You want to stay silent.
Let your attorney do the talking.
Right.
Unless you're spoken to by the judge.
Right. And even then you might want to ask your attorney, hey, this is what I'm going to say. Is that okay?
Okay. So, okay. That's interesting. Mm-hmm. Yeah. So that you do the pause again and ask, say, hey, I'm thinking about saying this.
Right.
Do you advise that typically?
I do. Yeah. I always tell people that they need to run anything that they want to say by me before they attempt to say it to a judge, a district attorney, or an officer. God,
does it drive you nuts when they just shout it out?
It's a little frustrating, yes.
Yeah.
But mainly because they're hurting themselves. They're, ultimately, I'm not the one that's going to be going to prison. My job is to try and do my best to keep you from going to prison. And so if you pay attention to what I advise you to do and do it, you're going to be in a better position than otherwise.
Hey, we've got a new catchphrase for you. Help me help you.
Right.
I'll be your marketing guy too.
Yeah.
All right. Well, thank you for joining us today on In Your Defense with Amy Bingham. If you'd like to connect with Amy, her website is amybinghamlaw.com. And of course, please like and subscribe and review us. We'd love to have you here. Amy, always great to see you. Thanks so much for the great conversation.
It's always good to see you too. Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.